All right, let's start with the second topic. Our topic will be Safe Spaces Act and Aggravating Circumstances. So, yeah, Safe Spaces Act, and then we will discuss Aggravating Circumstances, and we will also discuss the principle of suppletory application of the revised penal code. All right, let's get right through it. This Safe Spaces Act criminalizes gender-based streets and public spaces sexual harassment. All right, gender-based street and public spaces sexual harassment. So what is that? It's an unwanted, uninvited sexual action. It's an action or remark against any person regardless of the motive for committing such action or remarks, and it includes catcalling, wolf whistling, unwanted invitations, sexist slurs, misogynic slurs, uninvited comments, gestures, personal on a person's appearance, request for your personal details, pahingi ng number mo, pwede ba kitang dalawin, statement of sexual comments, ang sexy mo naman, some suggestions, baka pwede kitang iuwi, public masturbation, flashing of private parts, or groping. Take note, these all happen. These are all actions, and you are not yet interfering with the private space of the victim. All right, not yet interfering. But then, if you go to the next level, you advance. You can do verbal or physical also. You threat, and then you invade that personal space. By stalking, you touch the body parts, and you can do it public space. There's a next level. So this one is uninvited sexual remarks or maybe gestures or actions. But this in this type, we are not yet invading that private space of the person. In this second part, you are inviting the private space. Now that is prohibited, or that is criminalized by the Safe Spaces Act. And then Section 15 says there is a qualified gender-based street and public spaces sexual harassment act. There's qualified. And so what happens when you hear the word qualified in criminal law? What happens is the penalty next higher in degree will be applied. Now, this penalty next higher in degree will be applied is written on Section 15 of that law, Safe Spaces Act. All right. So, and this should remind you of aggravating circumstances. So what are aggravating circumstances? They are circumstances that when present in the commission of a crime or felony increases the penalty. That's the general description of an aggravating circumstance. And there are different kinds of aggravating circumstances. There's a generic aggravating, all right, that increases the penalty to the maximum period. A special aggravating circumstance, it's the law defining the offense or the felony defines that aggravating circumstance. The qualifying circumstance, penalty is increased to the next higher degree. Inherent aggravating circumstance, it not necessarily, which necessarily accompanies the crime and should not increase the penalty. Let's go through these aggravating circumstances one by one. All right. When you talk about aggravating circumstances, the general aggravating circumstance, the generic aggravating circumstance, we're talking about what's written in Article 14. All right. So this is how Article 14 looks like. So public position, contempt or insult to public authorities, insult or disregard of the respect due the offended party. All right. On account of rank, age, sex, committed in the dwelling. Or if the latter has not given provocation, if there's an abuse of confidence, take note, abuse of confidence is an aggravating circumstance. But if it's in estafa, it cannot be an aggravating because it is inherent. Right, so that's the crime can be crime committed in the palace of the chief executive. All right. Okay, let's go back. Public authorities are in the place dedicated to religious worship. Crime is done in nighttime, unhabited place by a band. Yeah, all right. We do it on the occasion of a conflagration, shipwreck, epidemic. Crime has been committed with the aid of armed men. There's a recidivist. This defines what the recidivist is. Just go through it. There's going to be another slide where we discuss recidivists. Previously punished. Okay, so there's a previous conviction. Take note that this can be qualifying. It can also be aggravating, generic aggravating, and also can be qualifying. We'll demonstrate that later. Price, reward, or promise. But of course, this should not be aggravating circumstance in kidnapping for ransom because it's inherent. The crime can be committed by means of fire, explosion, inundation. There's wrong spelling. Evident premeditation can be qualifying. It will qualify homicide to murder, but it will not. It is a generic aggravating for, say, physical injuries. Physical injuries, evident premeditation, it qualifies it so that the penalty is maximum. But it's a generic aggravating for physical injuries. It puts the penalty to the maximum. Whereas if it's homicide, there's evident premeditation, it qualifies it. It's no longer homicide, it becomes murder. Alright, so both bottom lines are the penalty is increased. Alright, so craft, fraud, disguise, advantage, superior strength, treachery, or there ad ignominy. So there's a lot, no? There's a lot of aggravating circumstances. Unlawful entry, take note. If it's robbery, this should not be aggravating. This should be inherent in robbery. Alright, there. Committed with the aid of persons under 15. Alright, deliberately augmenting the crime, na? Like this one, treachery can make it qualifying. Alright, so let's do it one by one. Generic, for example, in homicide, if you look at 249, the penalty is reclusion temporal. If you commit it in a place dedicated to religious worship, okay, since it is an aggravating circumstance, the penalty will be temporal maximum. Alright. If without this aggravating, it will be reclusion temporal. If it is committed by a recidivist, reclusion temporal maximum. Alright. Now again, if the law specifically defines it, for example, homicide 249, reclusion temporal, if there's quasi-recidivism, look at it in Article 160. If the person committing the homicide was after the trial or before the sentence, was convicted while already serving sentence, cannot be offset by mitigating. All right. If you look at 160, there's a penalty imposed by Article 160. All right. All right. So just to clarify that, Article 160 says if the accused is a quasi-recidivist, the penalty will be reclusion temporal maximum. And because it is a special aggravating, this quasi-recidivism cannot be offset by a mitigating circumstance. All right. Qualifying circumstance, well, the penalty is increased to the next higher degree, like murder. The penalty is reclusion temporal to death. All right. Now, if there's treachery or the occasion of calamity, homicide will become murder. From reclusion temporal, it will become reclusion temporal to death. And these qualifying circumstances cannot be offset by mitigating circumstances. For example, for inherent aggravating circumstances which are inherent in the commission of the crime, for example, if you look at paragraph 1 of Article 14, if there's an abuse, if the public position was used by the accused, that will be an aggravating circumstance. But if you're talking about malversation as a crime, public position should not cause the increase of that penalty, because the public position in the crime of malversation necessarily accompanies the crime-defined malversation, which is committed by a public officer. All right, so let's go back to this one. All right. When we talk about penalty next higher in degree in the context of gender-based streets and public spaces sexual harassment act, what does that mean? Okay, so these are the qualifying circumstances in gender-based streets, public spaces, and online sexual harassment. If it happens in a public utility vehicle, jeepney, taxi. If you commit a gender, if you do sexual harassment on a minor, senior citizen, person with a disability, a breastfeeding mother, or child. If you do it, if you commit sexual harassment against someone with a mental problem, if it is done by a member of the PNP, AFP, if it's done in a government agency, all right, it's qualified. What will happen? The penalty next higher in degree will be applied. And that is why we talk about suppletory application of the revised penal code. If you look at Article 10, it says, well, these are the words you'll see there. The revised penal code is not applicable when special law penalizes a particular act, but it is supplementary to special law unless the special law provides the contrary. That's what Article 10 says. And so in jurisprudence, the Supreme Court had to clarify it. So the general rule is, and that's in People versus Simon, revised penal code principles will not apply in special law if let's say it in reverse. Revised penal law principle will apply suppletorily to special law if the special law uses the nomenclature of the penalties of the revised penal code. All right. So does the revised penal code apply to the Safe Spaces Act? The answer is yes. Why? Because if you look at the penalty in the first offense, in this type of sexual harassment, where there's catcalling, wolf whistling, comments outside the personal space of a person. Look at the penalty. It says arresto menor, on the second offense. So the first offense, what happens is, if these catcallings are committed, the first offense, the penalty is a fine. There's a 10,000, 1,000, or 10,000 and community service. All right, and then the second offense, there's arresto menor. Third offense, arresto menor or arresto mayor. Take note. So, will the revised penal code principles apply? Yes, because the penalty used by the Safe Spaces Act is of the nomenclature of the revised penal code. All right. On the other hand, if you look at this type of sexual harassment, the one where personal space is invaded, that is by stalking, when you start touching the body parts of the victim, all right, when there's an advance, and you touch the body, the penalty, first offense is arresto menor there. The second time you do it, arresto menor or mayor or a fine, all right, or arresto mayor maximum. All right, so this happens when there's a stalking or a stalking with body touching. All right, so that's it. That's how we are explaining the concept of suppletory application of the revised penal code to the Safe Spaces Act, and the discussion on the aggravating circumstances.